I'm Jeff Rosen. I'm a law professor at George Washington University and a co-editor with Benjamin Wittes of Constitution 3.0, Freedom and Technological Change. We asked in the book a group of thought leaders to imagine what the world would look like in the year 2035 and how it might be changed by technology and how law might evolve to preserve the same values that the framers of the Constitution took for granted. So we have a range of fascinating essays trying to imagine the future of free speech, of privacy, of genetic engineering, designer babies, patenting human life, issues involving internet governance and neuro law. And in each of these areas, people cast their minds forward a few decades, tried to imagine a concrete scenario in which current constitutional values might be challenged, and then proposed a range of solutions for dealing with that. To some degree, the subjects were determined by the interests of the participants, but we had a broad sense as we invited people about what some of the areas we wanted to explore were. Privacy was a natural one. I've been thinking about it for a while, and there are so many challenges to privacy in the age of Google and Facebook. Neuro law was another, the ability to look inside people's brains and ask them questions that lie detector tests in the past couldn't begin to fathom, and perhaps hold them accountable for their thoughts rather than their actions. The questions involving free speech in an age where Google now has more power over who can speak and who can be heard than any king or president or Supreme Court justice. Questions involving the future of criminal responsibility and so forth. So essentially, Ben Wittes and I just sat down, tried to imagine between the two of us what some of the interesting challenges might be, and then chose people and invited them to let their imaginations run free. We chose a great group of people. It includes, writing about privacy, Christopher Slobogin, who teaches at Vanderbilt, Professor Kerr, my colleague here at GW, and it also includes for free speech Tim Wu from Columbia, for neurolaw Carter Sneed, who's at Notre Dame, and Stephen Morse at the University of Pennsylvania. We have Jamie Boyle imagining the future of copyright and efforts to patent human life. In terms of designer babies and genetic selection, we have John Robertson from the University of Texas and Robert George and Eric Cohn from Princeton. And our final essay comes from Lawrence Lessig, who is an internet guru and tries to cast the whole book in a broader perspective and extract common themes among it. We asked them to begin with a concrete scenario that the country might plausibly confront in the year 2035 and talk about how that scenario challenged current constitutional values or doctrine, and then try to imagine a solution to the challenge. And what was so striking is that the range of solutions that people proposed. Some preferred judicial solutions and thought the Supreme Court should step in to protect constitutional values. Others preferred legislative or administrative solutions. Still others emphasized the importance of political activism and the need for citizens to defend their own rights. So it was an ideologically diverse group. There was no consensus about the right way to go, and it was just striking how complex the solutions were and how many moving parts, how much interaction among various policymakers were often required to produce a good result. It was striking how many of the respondents imagined a future that might plausibly take place not in the year 2025, but 5 years from now or even at the moment. So my scenario is an illustration of this. I imagine that in the year 2025, Facebook might be asked to put online all the public and private surveillance cameras that are now distributed throughout the world. And this is indeed already happening. Facebook has an app where you can watch live beach cameras from Mexico, which are popular with teenage boys for reasons you can imagine. So imagine that the beach cameras from Mexico are linked with the subway cameras from New York, with the hospital cameras in London. These images are archived and stored. You can sign on to Facebook, click on a picture of me, for example, back click on me to see where I'm coming from, forward click on to see where I'm going, and basically have 24/7 ubiquitous surveillance of anyone in the system at any time. The reason this isn't science fiction is because I was at a conference at Google in 2007, and the head of public policy at Google, who was then Andrew McLaughlin, said he imagined within 5 years Google would be asked to do precisely this. So that brings us to 2012. Presumably there are already requests from the private and public sector to link and store cameras online, and it really is just a matter of time before this scenario, which I called open planet, will actually confront us. That is the question. What is the problem, and is there a problem? Remarkably, this is the very problem or question that the Supreme Court confronted recently in the Jones case, US v. Jones, involving GPS tracking. And that was a case involving a police officer who put a global positioning system device on the bottom of a suspect's car without a valid warrant and tracked his movements 24/7 for a month. And he then sued and said because there hadn't been a valid warrant, the search was unconstitutional and the evidence should be excluded. Several lower courts and the Obama administration took the position that we have no expectation of privacy in public. And because it's theoretically possible for our neighbors to track us down the street or for the cops to follow us for 100 miles, therefore the police should be able to use technologies like GPS devices to achieve the same surveillance virtually rather than actually. But in a visionary decision, a remarkable decision, the Supreme Court unanimously disagreed. It repudiated the position that we have no expectation of privacy in public, although the justices disagreed in important ways on the relevant reasoning. A majority of the court joined Justice Scalia's opinion, essentially saying there was a physical trespass involved when the GPS device was placed on the bottom of the car that interfered with the suspect's possessory interests, and therefore a search did take place, although the court didn't say clearly whether a warrant was required in all cases. But four justices were willing to go further. They said, repudiating the idea we have no expectation of privacy in public, they said there's a huge difference between surveillance for a day and a month. And although it's theoretically possible for the cops to hire 1,000 officers who could tail you from door to door, in practice that doesn't happen because of limited resources. And citizens don't actually expect that they're going to be tailed door to door for a month because it doesn't happen. And therefore, said Justice Alito, joined by 3 other justices, a warrant should be presumptively required for long-term surveillance, perhaps not for short-term surveillance, although the justices refused to specify the precise point at which a warrant might be required. They said if you're not sure, then you should get a warrant. So this obviously has direct and huge implications for Open Planet. We now have 4 members of the court, and really probably 5, because Justice Sonia Sotomayor wrote a concurrence where she signaled a willingness to go further in some respects, have suggested that for long-term ubiquitous surveillance of people, even in public places, a warrant is presumptively required. And therefore, according to this reasoning, if Google and Facebook did link up the cameras and create an Open Planet system, the police could not track a particular individual over an extended period of time without a warrant. That appears to be the holding of Jones, and that seems to me a sensible result. It's intuitively clear that there's a huge difference between what the police can learn about you when they follow you for a few minutes and what they can learn about you over the course of a month. The month-long surveillance reveals the newspapers we read, the people we associate with, the bars we visit, the private associations and feelings we have, and to refuse to require a warrant for that intrusive a search would give citizens less privacy in the 21st century than they took for granted in the 18th. And that's really the challenge that I tried to confront in the chapter. How can we avoid allowing technology to erode privacy? And that's why I'm so encouraged that the Supreme Court accepted this invitation. It's a crucial question. Is there a difference between surveillance by the police using government cameras, and surveillance by fellow citizens on Google using the Google and Facebook platforms. After all, the Fourth Amendment to the Constitution binds the government. It doesn't bind Google. And if Mark Zuckerberg or the good people at Google decided to use their own servers to link up surveillance cameras, it might be argued that that's not a constitutional issue at all. Citizens are free to spy on each other using private technology without implicating the Constitution. Now, it becomes more complicated when the government tries to use the system to conduct its own searches, and more complicated still when there's a mix of public and private cameras, and the court would have to decide whether or not there's state action and so forth. But the difficulty of answering the question points to a theme that united many of the chapters of the book, which is the difficulty of thinking through constitutional rights and liberties in an age when the great internet service providers have more power over speech and privacy than the government does, and yet they are not formally restricted by the U.S. Constitution. Because they are. No one can deny the fact that if you want to know who determines who can speak and who can be heard today, it's not the U.S. Supreme Court, Justice Scalia or Justice Alito. It's the lawyers at Google. In particular, Google for a long time has had a particular lawyer, and until long ago her name was Nicole Wong, and her colleagues actually called her the decider, because she was the one who was empowered to decide what stays up and what comes down not only on Google.com, but on each of the more than 140 search engines that Google does business with around the world. Google France and Google Germany, and also on YouTube, which Google owns. So Nicole Wong was the person who's woken up in the middle of the night when the Turkish government is complaining because Greek football fans are posting YouTube videos accusing Kemal Ataturk, the founder of modern Turkey, of being gay, which Greek football fans love to do to get a rise out of their opponents. It's illegal in Turkey to insult Ataturk. And Nicole Wong, who's pledged to take down material that's clearly illegal under local laws, has to make a spot judgment at 4 in the morning. Is the material clearly illegal? Is it protected political speech? Is it on the edge, in which case maybe she'll leave it up? She doesn't speak Turkish. This is only one of 100 controversies bubbling up around the world. The sheer scope of the responsibility helps to dramatize just how much power the internet service providers have. There's no question that corporations have had an important role in who can speak and who can be heard throughout American history. And in fact, Tim Wu begins his chapter by imagining a situation in which Google decides to favor one presidential candidate over another in a close race and uses its power over the internet to ensure his victory. And then Tim Wu notes this isn't just a fantasy. In fact, in the 19th century, in the contested election of 1876, the Hayes-Tilden election, AT&T did allegedly use its power over the telegraphs to favor one candidate over another. So no question that the risk that corporations can pose to speech and liberty, so memorably recognized by my hero, Justice Louis Brandeis, in his denunciation of the risks that bankers take with other people's money, and the curse of bigness that allowed concentrated corporate power to suppress liberty. This has existed throughout American history. However, it's also the case that today, now that so much more of our public life takes place online, obviously than it did before, but now when much of our public life takes place online, we're in a different situation than we were during World War I, when the quintessential example of speech suppression was the street corner speaker standing up in Hyde Park or on the Boston Common and denouncing World War I, and then the government under the Espionage Act threatening the speaker, as it did Eugene V. Debs, the socialist candidate for vice president, who's imprisoned for his speech in a public meeting. Now, the Eugene V. Debs who's making anti-war criticism is going to do it online, in blogs or on Facebook. And that means that, or on Twitter, certainly. And therefore the question whether or not to let him speak in the first place, to try to censor him after he's spoken, will be made in the first instance by the internet service providers, not by the government, and that technological shift has vastly increased their power over speech and privacy. I don't think that Tim Wu and I disagree fundamentally that in some situations judicial resolution is appropriate, and in some cases regulation is appropriate, and in still others political activism is necessary. We just focused on different challenges. So I think that the courts are important as a backstop, and had they not stepped in the Jones case to say that there is some expectation of privacy against ubiquitous long-term surveillance, then we would have had far less privacy today than the framers took for granted. But I don't at all believe that the Supreme Court is going to have the last word in these great privacy debates, precisely because Google and Facebook have more power than the government about who can speak. I agree with Tim Wu that administrative regulations are going to be just as important as constitutional doctrine, in particular antitrust law. Are Google and Facebook having uncompetitive advantages by the scope of their control over speech? Or, to take a European example from just this week, should there be a legislative right to be forgotten on the internet? That's what the European Data Privacy Commissioner Viviane Reding proposed just this week. It's extremely unclear what the scope of this right is. In its narrowest form, it seems to allow citizens to require people who hold data about them to delete that data when it's no longer necessary. But it becomes more controversial when it appears to give people the right to request the removal of pictures and items about themselves that have been widely shared. At that point, there's an obvious clash with free speech. So, to take one example, there was an Argentinian pop star, Virginia de Cunha, who'd posed for racy pictures of herself. And then she grew up and she thought the better of it, and she asked Google and Yahoo to take the pictures down, even though they'd been widely distributed. They refused. They said they're not, they don't make content-based decisions, and the pictures were out there too widely. She persisted. She sued. An Argentinian court ruled with her, holding that her dignitary rights, embodied in a kind of right to be forgotten, had been violated, ordered Google and Yahoo to take down the pictures, and after being fined a lot of money, Yahoo said, it's too hard for us just to remove the dirty pictures, the racy pictures. We're going to remove all references to this woman from the Yahoo search engine. So this just shows how dramatically this right to be forgotten allows you to delete your past selectively on the internet. American law would not strike that balance between privacy and free speech. We generally hold that people cannot be restricted from sharing or publicizing truthful but embarrassing information about people. That's what the court has held repeatedly. So I think we're about to have a dramatic clash between Europe and America when it comes to the appropriate scope of regulation. But that just shows that this is not a debate that comes from the Supreme Court or the European constitutional courts. It comes from the European Union. Congress may reach a different balance. It's a legislative debate. And then finally, there's the question of whether political activism is more important than legislation or judicial decisions in some areas. And here, I like very much the example of the triumph over the body scanners. It's such an optimistic, happy story for privacy advocates. But this is the story of the naked machine versus the blob machine. Originally, in 2004, the Bush administration was offered a choice between two designs of body scanners. One design revealed contraband and plastics and so forth under clothing, but also showed graphic images of the naked body. Another also revealed the place the contraband was located, but scrambled the naked body into a modest and nondescript blob, and basically just told the screeners where to look under clothing in secondary screening. From a security point of view, this is a no-brainer, as they say. The same amount of security, one grossly invades privacy, the other protects it. However, the Bush administration, the Homeland Security Department, chose the naked machine over the blob machine. Their privacy officers didn't require the less intrusive technology. They ignored evidence that neither machine was all that effective in detecting low-density chemical ETN powder, such as used by the Christmas trouser bomber. But they reached a different conclusion than European airport authorities, most of whom rejected both machines, but the handful of whom the handful of European airports that chose these technologies insisted on the blob over the naked machine. So why is this a happy story? Because there was a political protest. It began with the clarion cry of the hero of the naked body scanner movement, the guy who memorably exclaimed, "Don't touch my junk." That led other citizens to refuse to go through the machines or to be patted down. And finally, embarrassed by this citizen uprising, the Obama administration instructed the Homeland Security Department to go back to the drawing board, and they were shocked to discover that, in fact, they could choose the very blob machine technology that they'd refused to choose years earlier. So that reminds me, or that illustrates for me, the idea that we can't rely on courts alone to protect privacy, nor on legislators. In the end, or especially in some circumstances, citizens have to rise up and demand their own privacy, and it's only by galvanized political activism can a good balance be struck. I am reluctant to generalize too much about the virtues of corporations versus the government. Each has its own interests that threaten and can protect liberty in different ways. So there's certainly some areas where some corporations have an incentive to support transparency and open network rules. Network neutrality is a good example of that. It's certainly in the interests of Google and Facebook and the great ISPs to ensure that particular applications can't discriminate against their competitors and degrade or block any item or data. So that's why Google supported net neutrality. But it's not, net neutrality isn't in everyone's interest. Comcast, the phone company, wanted to be able to block BitTorrent, which had a potential to compete with its own file sharing service, and also to charge more money to particular applications that consume more bandwidth. So similarly in the debate over internet piracy, I was struck by some of the techno-meliorism, the kind of powerful versus the people rhetoric that seemed to pit the greedy old media companies in Hollywood who were trying to argue for enhanced copyright protection against the tribunes of the people at Google and Facebook who felt that information should be free. It's not that simple a story. In fact, although SOPA itself was a very bad idea and the structure of the internet should not be changed in order to go after what's ultimately a handful of really serious copyright violating sites located abroad who are better dealt with through a law enforcement approach, such as we used against child pornography. Nevertheless, that's not to say that Google wins and journalism and perhaps independent artists and filmmakers and musicians may lose when the business model that allow media companies to fund and to promote quality work evaporates. So yet again, you'll find some companies have more of an incentive for transparency and free information, but that may not serve the public interest in all circumstances. Certainly companies don't have the same incentives that government does to keep information secret in the interest of national security. Their interests are financial and proprietary. They want to protect their trade secrets. But we should never forget for a moment that Google and Facebook, as wonderful as they are and as much as we depend on them, are in the advertising business. Google, their business is to learn as much about us as possible so that they can bombard us with ads that will track and follow us as precisely as possible across the entire range of platforms in which we interact. And the values of an advertising company are not the values of James Madison. They have different financial incentives. They need to be constrained in different ways. So I'm not someone who believes that liberty will flourish and secrecy will wither on the vine now that we have to be more concerned about the power of Google than the power of government. People have long criticized the expectation of privacy doctrine for being circular, but technology is making it even less satisfying. So the circularity is obvious in the fact that our expectations of privacy depend on the amount of surveillance and incursion that we actually experience. And as technology makes those incursions more ubiquitous, our expectations diminish and there's a corresponding diminution in constitutional protections. But so that's just to say that in an age when if the government were to set flying miniature robots in the air and take out ads on the internet telling people that they might be spied on at all times by Open Planet, our expectations would diminish, and then the question is, should we have any residual protections? That was a question that the court in Jones didn't answer clearly. Justice Alito did seem to say that the relevant test was what citizens actually and realistically expected, but that seemed to set the stage for something like Open Planet to proliferate as long as it was done quickly and there were lots of warnings taken out about it. Technology has also changed our expectations because unlike in real space, although we may know in a theoretical sense that we might be viewed out of context, it's not our actual experience. So on Facebook, people expose stuff imagining that it's going to be basically viewed by their friends. And although they may be warned and told that the friends might share, or Facebook may have boilerplate disclosures warning that Facebook has access to the data, we don't actually imagine that it's happening, and then we're shocked and surprised and discomfited when Facebook ends up tracking us on the basis of conduct that we didn't imagine was going to be used for selling us ads as opposed to sharing with our friends. I think these are all additional reasons why we need to rethink the expectation of privacy doctrine. At some point, Congress or the courts or the mobilized citizens of the world are going to have to say, regardless of how much Mark Zuckerberg warns us that he is collecting and tracking our data, there is a point beyond which that becomes unreasonable and an indignity. And defining that point is tough, which is why the Supreme Court was understandably reluctant to specify the difference between surveillance 24/7 for a month and surveillance for a day. But unless that line is defined judicially or legislatively, then we're at the mercy of the technology. Yes, there are two really rich and provocative contributions about the future of neurolaw. And both of them begin with the idea that neuroscience is changing our traditional conceptions of criminal responsibility. So traditionally in Anglo-American law, you're held responsible for your freely chosen actions. Unless you literally act under duress, someone points a gun to your head, steal or else, or a defect in understanding that meets the legal definitions of insanity, you're held responsible for your actions. Neuroscience is now presuming to say that some people, because of their brain structure, are less able to control their impulses than others. If you have an overly active amygdala, which is the emotion control of the brain, and underactive prefrontal cortex, which is supposed to be the conscience which restrains the amygdala, then, according to this defense, my brain made me do it, I couldn't conform my actions to law. And some criminals, convicted criminals in death penalty cases, are, as a matter of course, introducing this brain made me do it defense in order to argue, if not that their conduct should be excused, at least it should be, their punishment should be mitigated. So far, these defenses have not been all that successful. It's allowed in under the relaxed evidentiary rules that happen at sentencing, but juries are not buying it much. Nevertheless, according to some philosophers, the more we learn about the brain, the more we need to abandon our whole notion of retribution being an appropriate goal of criminal punishment. If it's true that we're really all slaves of our brain, and that my decision to have a salad rather than soup for lunch was predetermined by my brain structure as well as by my, the way my mommy and daddy treated me, which was delightful, and other things that I can't control, then punishing me for my criminal actions seems no more fair than punishing a robot or for acting according to a program that it can't control. Instead, it might be appropriate to emphasize deterrence, to lock me up forever because we're afraid my brain is going to make me choose the bad action again. But blameworthiness is no longer appropriate. One of our contributors, Carter Sneed, made the very interesting point that this might not be great for liberal values or even for accused criminals. After all, if it's not appropriate to punish people based on their blameworthiness, it's also not appropriate to mitigate their punishment based on their acceptance of responsibility. And if you're really only concerned about restraining or deterring automatons from bad actions, you might have more capital punishment, not less. So it's not at all clear that the side of liberalism will be served by these brain made me do it defenses. But in addition to all that, brain science is calling into question not only our notions of responsibility, but also ideas about lie detection and also deterring people for future bad acts. So for lie detection, already apparently there are some fMRI scans that purport, when you show someone a picture of a place they've been, like a training camp in Afghanistan, to detect the brain lighting up in a particular way, and if they haven't been to the training camp, then it won't light up. And this is supposed to be more accurate than current lie detectors, although not accurate enough to be admitted into court under the Supreme Court's evidentiary standards. Once this gets ready for prime time, which it will soon, then you could well imagine picking someone off the street, giving them a brain scan. If their brain lights up to the training camp, off they go to indefinite detention. Now all of a sudden we're getting some very troubling questions about holding people accountable not for the acts that they've committed in the past, but for the bad acts they might commit in the future. And as the brain scans become more sophisticated and purport to show pictures of broken brains, people with more gray matter in their prefrontal cortex are supposed to be more predisposed to violence, might it not be possible to actually emphasize who is most likely to commit a bad act in the future, scan their brains, create a profile of the potential terrorist, and indefinitely detain people based on their future bad actions? This would gravely challenge the idea in Anglo-American jurisprudence that you should be held responsible for what you do, not for what you think, for your actions rather than your predispositions. But our two interlocutors, Snead and Morse, struggled very interestingly with the degree to which this technology will challenge those traditional liberal values. It's so striking, isn't it, that although the idea that we should punish people for their actions rather than their predispositions seems to be a constitutional value, it's hard to point to a particular provision of the Constitution that guarantees it. The court has said that sex offenders, for example, may be indefinitely detained in the future based on their future dangerousness, because the connection between the past impulses and the future bad action are supposed to be so direct. This isn't viewed as a punishment, but a civil confinement necessary to protect society. Now, it's true that sex offenders have to be duly convicted of an offense before they can be indefinitely detained. But I think all of us can imagine that if the technology got good enough at predicting accurately whether people who hadn't yet committed bad acts in the future might, because of their brain structure, we could well imagine efforts to detain them as well. And of course the justification would be this is for their own good, this is civil detention, it's for the protection of society, we're not punishing them, we're just preventing them from acting according to the irresistible impulses of their brains. So if that were the case, what constitutional provision would forbid this sort of detention? The nearest analogy almost seems to be the Bill of Attainder clause, the constitutional provision that prohibits Congress from passing bills of attainder, which of course were the efforts to criminalize people based on their status, not their conduct. So if, say, I, Jeff, committed treason against the king in the old days, not only would I be a taint and I would be grotesquely disemboweled in a very ceremonial way, but and executed, but not only I, but my children would be strangers to the law, and they would have no ability to have offices of honor or profit, and they would be banished, and they wouldn't have the protection of the laws, and essentially they would be people without legal status. That would be visiting the sins of the father on the children, and the Bill of Attainder clause is designed to prohibit that. So you could say that if the brain scan reveals that I'm likely to commit bad acts because of the bad brain that I inherited from my father, it would be like a Bill of Attainder. But it wouldn't actually be a Bill of Attainder. Congress wouldn't have passed this the law that formally made me a stranger, an outlaw. So it's an analogy, but not a conclusive argument. And we could certainly construct constitutional arguments about that would call into question indefinite detention based on predispositions. You could say that this was a form of deprivation of liberty without due process of law, that due process requires that you're duly tried and convicted by a court before you're detained. But of course, the Supreme Court has signaled that when it comes to terrorism and the category of enemy combatants, a trial might not be necessary if you're found on the battlefield. So maybe the analogy here would be it's the violent brain is like being found on the battlefield. The point is not to resolve these issues, but just to suggest how dramatically an issue that you'd think would be clear under American law, namely you can't detain people for their predispositions, isn't clear, how the existing constitutional doctrine is challenged so dramatically by this technology. Yes, Oren Kerr has a very helpful and illuminating suggestion when he emphasizes use restrictions. His basic point is that the collection of data is very hard to regulate. The cat is out of the bag. We're already leaving so much data trails everywhere already that an attempt to prohibit it being from collected and even integrated may be foolish. But he emphasizes use restrictions could make a big difference. There's a model here. The Germans, who have an obvious and daunting history of totalitarianism, allow their intelligence services to have broad access to data without a warrant. But they can only pass that data on to law enforcement if they find evidence of terrorism or other serious crimes. If the intelligence services were to find evidence of low-level wrongdoing, like adultery, for example, they would not be able to share that information with law enforcement. That's a quintessential example of a use restriction. You can share the information when it relates to a serious crime, but not when it relates to a low-level crime. And Professor Kerr argues, and I agree with him, that similar use restrictions in the U.S. would go a long way toward alleviating a lot of the concerns about unlimited government access to data. We'd be less concerned about surveillance on an open planet-like system if the police were only allowed to use the information they learned to prevent murder and terrorism and not to go after people for lying on their tax returns. Unfortunately, and Professor Kerr doesn't examine the practical likelihood of this, but I think he would argue, and I'd agree, that it's not likely to pass in practice. It's hard to stand up in Congress and say, we have to allow the police to go after the murderers, but not the adulterers. Imagine standing up and saying that. Or as I found when I interviewed Larry Ellison of Oracle years ago, who runs the largest database company in the world. And he had just proposed, it was right after 9/11, to offer the US government free software for databases. Coincidentally, they were going to be Oracle databases. And also coincidentally, the maintenance and upgrades weren't going to be free. But he wanted to centralize all the data the government holds in an Oracle database and check people before they go on airplanes to see whether they had anything bad in their past. And I objected, but wouldn't this mean that if you were late on your child support payments, then you could never board a plane or get into a government building? It's one thing to keep a terrorist off, but another thing to keep off an adulterer. And he got very indignant and said, well, what's so great about protecting people who are late on their child support payments? You know, if you do something wrong, you've got to take the consequences. Nothing to hide, nothing to fear. And that's a very popular position in the country as a whole. John Ashcroft, the Attorney General, said a similar thing when I suggested use restrictions in an interview with him. So in a democracy, it's tough to argue for use restrictions. That's why I think that the Europeans are more likely to impose these use restrictions through non-democratic, or rather non-plebiscitary bodies, not through their legislatures, but administrative bodies. They put more faith in the power of experts to restrict information. Their data privacy commissioners have more power. So you almost need an administrative regulation to implement use restrictions. We can't rely on politicians to do it. Jack Goldsmith does have a wonderful essay about how much more of this surveillance is already going on than we imagine. And he talks about the Einstein 3 program, which the government has acknowledged in the vaguest, most general terms. And under Einstein 3, in an effort to avert cyber attacks, the government is asserting the power to scan all internet traffic coming from abroad, and when it detects any suspicious patterns, to intervene in real time to destroy the information. This is a version of the warrantless wiretapping that the Foreign Intelligence Surveillance Act and other laws seem to forbid. But, says Goldsmith, could it be justified in the name of exigency? He thinks that you'd need a legislative fix. Congress would have to pass a law explicitly authorizing Einstein 3 to put it on really solid legal footing. But he also notes that in order to be consistent with Fourth Amendment values, although not necessarily with the Fourth Amendment itself, you would need a series of use restriction-like devices. He talks about minimization requirements that would require the data to be destroyed after a particular period of time if it didn't contain anything suspicious, independent oversight by judges, and sunset provisions that would ensure that the authority would expire after a certain period of time unless Congress wanted to renew it. So for him, I think he imagines that these restrictions should be embraced by Congress, although he's not all that optimistic that they will be. He notes that similar restrictions were recommended by things like the Berger decision, the Supreme Court's decision regulating wiretapping. There, Congress did respond by passing the kind of restrictions that the court recommended. I think we'll see whether the Congress responds to the Jones decision by accepting Justice Alito's suggestion that we need a global positioning system legislation, and that it's not up to courts alone, but that some sort of legislative regulation of access to geolocational data is necessary. But this is such an important problem because it's a solution without a natural constituency, and it's just not obvious, I think, to any of our authors exactly whether the good results that they suggest will in practice be adopted. Yes, the Jones case is interesting and encouraging on a lot of levels. It's interesting and encouraging that all of the justices, liberal and conservative, rejected the position that there's no privacy in public. It's encouraging that each of them contributed something promising for the future. So it's a good thing that Justice Scalia and his colleagues said that trespass law may not be the ceiling for Fourth Amendment protections, but it's at least a floor. It's a good thing that Alito was so willing, in a very creative way, to entertain and recognize the difference between short and long-term surveillance. And it's great that Justice Sotomayor called for re-examining the third-party doctrine, which says that data that I share with a third party like Google is data in which I abandon expectation of privacy and which Google can then share without limitations with the government. It's also encouraging that the justices seem to be as tech-savvy as any normal citizen in this world. You know, there was a lot of ridiculing of them on the blogs for their supposed tech Ludditism in the oral argument about the privacy of a beeper, the Kwan case. Justice Roberts was criticized for asking a question that seemed not to understand what text messaging technology was, and others noted that Justice Kagan, the youngest justice, grew up with a video game technology that went no further than Pong. And then, of course, in the Communications Decency Act case back in the 90s, there were apparently, according to press reports, porn tutorials in the Supreme Court library where Larry Lessig, who was then a clerk for Justice Scalia and is also an internet guru, had to set up computers and show the justices how to sign on and access internet pornography, no doubt sternly cautioning them not to engage in this hideous vice in their spare time. But in this case, we learn that the justices are citizens of the new digital highway along with the rest of us. They get Easy Pass, they use Kindles, they use email, they have smartphones, and therefore they are not going to allow the fact that they are old and in that sense less tech savvy than younger people. They won't allow that to prevent them from engaging this crucial question of how to translate the Constitution in light of new technologies. I am very skeptical of generational claims when it comes to the privacy debate. It's true, younger people have different norms of exposure than older people in some regards. They're more willing to go through naked body scanners at airports because they look much better than the rest of us. They are more willing to share details of their personal lives on Facebook. But these same young people are quite savvy about editing their Facebook profiles the moment they graduate from college or law school and are applying for jobs, and are so savvy that they may remove a lot of the embarrassing drunken Facebook pictures, but leave up one or two because they've learned that if their profiles look too clean, the employers will think that they're trying to hide something. So as all of us grow up in this digital world, we all adjust to its exigencies, and it's not the case, I think, that this great new kumbaya universe, everything is going to be shared and we'll just get over our hang-ups about seeing each other's secrets, and light and sweetness will prevail. It's not descriptively right, and it's also would be a undesirable world to live in. Nevertheless, will norms change in light of new patterns of behavior? Of course, of course. People are not going to draw the line in the same place. Certain forms of exposure that used to be frowned on will be embraced. Much of that is to the good. Many people have complained about the paternalistic aspects of privacy, efforts to keep women in their place by enforcing norms of modesty. I mean, there's no point in being a Luddite or a moralist in acknowledging that the degree to which technology is changing norms of privacy. The one thing I want to resist is the claim that there will not always be some line that is important to draw and defend. And there will always be some invasions that are unreasonable. If we're to be secure in our persons, houses, papers, and effects, as the framers insisted, then there are certain forms of observation and surveillance that will have to be considered unacceptable. And that's why it's so important that courts, legislatures, and citizens negotiate those lines and insist on them, and not lazily insist, oh, no one will care, you should just get over it, and so forth. Reasonableness requires judgments, and those are the kind of lines that we have to draw. Yes, that's a very good way of putting it. The Constitution asks questions rather than providing answers, and it identifies constitutional values that change over time and may not always rise to the level of being constitutional rights. It was so striking throughout the book that in many cases there was some value that was being threatened, even though there was no obvious right that was being threatened. The problem of forgetting on the internet is one of them. It's very difficult not to be able to escape your past, to lose a job because of the ill-advised drunken Facebook picture that you posted. That doesn't mean that you have a right to have it removed, and it doesn't mean that if a right is created, as Europe is trying to do, that won't have bad consequences on other constitutional values like free speech. So that's why it's such a complex and fascinating area. But what's so inspiring about our beautiful Constitution is that it provides a framework for discussion that challenges us to preserve values in the face of change, as they always have changed. The technology has always challenged our constitutional values. We've responded in more and less effective ways, but at least there's a framework for the conversation that we can root in the text and history of this wonderful document. It's a hard and important question. Is technology transforming our constitutional debates in degree or in kind? Are these entirely new challenges, or are they just different versions of the old questions? You can argue it either way. I remember once making the argument that the challenges were new, and Kathleen Sullivan, then the dean of Stanford Law School, said, no, this is just the Winnebago problem. And what she meant by that is everyone who takes criminal procedure in law school knows all of those line drawing cases trying to figure out when a passenger compartment becomes a trunk. And the challenge is the Winnebago, which looks like a combination of a trunk and a passenger compartment. And for Kathleen Sullivan, there were always technological challenges to privacy. Brandeis worried about the Kodak camera and the tabloid press. And now we have Facebook, so many more people are affected than the aristocrats in Brandeis's day who worried about their social privacy being invaded. Now it's 800 million Facebook users rather than 3 Boston aristocrats, but it's just a difference in degree rather than kind. I respect that position, but my instinct is something has changed in kind, and that is the fact that the private corporations now have so much more power over these values like privacy and free speech than they did 100 years ago. It's true that there was the Kodak company, but it had so much less ability to affect our entire national debate than Facebook did, that it strikes me that the challenge of translating constitutional values into a world where they may not even apply to private actors is a distinctly new problem that's become more acute. But there's no point in fussing too much about this. I'm perfectly willing to acknowledge that maybe it's a different degree. Maybe it's a difference in degree, but if that's the case, it's a really, really big difference in degree. I'm so glad you asked about my hero, Justice Brandeis, and I can't resist this opportunity to plug him. Here, I've got him sitting right here on my windowsill, so I'm going to bring him over and have him gaze soulfully into the camera. You see his Lincoln-like profile, which was so admired, and I'm going to have him looking soulfully out the window because he was so... Mr. Justice, I'm being very respectful and holding you near me here, but this great man, more than any other justice of the 20th century, insisted on the task that we've been talking about today, which is constitutional translation. He never would have accepted arid formalisms which said that if the framers defined privacy by the law of trespass, then only the law of trespass should govern. In the Olmsted case, where the court refused to regulate wiretapping because there was no physical trespass of a suspected bootlegger, he looked forward to the age of cyberspace and accurately said ways may someday be developed by which it's possible to extract secret papers from desk drawers and introduce them in court. He anticipated Skype, or the kind of technology that we're using in this office today. He said, at the time of the framing, a far smaller invasion was held to violate privacy, the search of private desk drawers to read diaries. We need to translate the Constitution to guarantee as much protection in the 21st century as the framers took for granted in the 18th. I'm heartened and encouraged that a majority of the Supreme Court accepted Brandeis's challenge, and that Justice Alito cited Brandeis's dissent in Olmsted in insisting on the necessity of constitutional translation. But I believe that Brandeis's example showed that we cannot rely on judges alone. Why was it that in 1890 there was no national constituency for trust busting, but by 1913, the election in which Brandeis was advising Woodrow Wilson, two of the major presidential candidates, Wilson and Roosevelt, were both declared in opposition to the money trust, to the curse of bigness, and determined to pass antitrust legislation to rein in the banks. It was because of political activism. It was because the progressives started as an elite movement and insisted on the importance of expert opinions, but also mobilized citizens to lobby state legislatures who passed laws like the minimum wage laws and prototypes of antitrust laws, and created a bipartisan national constituency around trust busting. I look at the political debate today, and I'm encouraged, frankly, by the similarities, not the dissonance, but the consonance between the Tea Party and the Occupy movements, not in all respects, obviously, but in their opposition to the banks and their fear of concentrated corporate power, they suggest that there might be a mobilized constituency for curbing unlimited corporate power. Whether they will end up convincing the major political parties to pass regulations that rivaled that of Roosevelt and Wilson, or whether they fade away, as so many other fringe movements have, depends on whether they can persuade the mainstream presidential candidates, Romney and Obama, that they really have the numbers to make a difference. But I think, using them as a model, that Brandeis would have insisted that these issues involving technology in the Constitution are not ones that should be limited to judges or administrators or experts, or certainly not, God help us, law professors. They're issues that all citizens have a stake in and a duty to engage. The ability to defend constitutional values is our most precious heritage as Americans, and we have to seize it. And that's why I always love inspiring myself with Brandeis's wonderful words. He said, if we would guide by the light of reason, we must let our minds be bold. Thank you.